Welcome to another Glasgow Wants to Know. Tonight we have the two candidates for district judge in the judicial district that includes Barren and Metcalfe counties. They are Mitchell Nance and Carla Allen. I have known each of them since they started practicing law, and therefore I'm going to waive certain formalities and I'll refer to you as Mitch and Carla. And that way I believe we'll get along a little bit more smoothly. And since you're the challenger, Mitchell, I'll start with you.
Yes, sir.
Tell the public your background, including education and so forth.
Thank you, Mr. Barrickman, and thank you to the Electric Plant Board for making this evening possible. I was born in Glasgow in 1951. My parents were the late Elton Nance and Bessie Nance. My mother and my brother David live here in Glasgow now. I attended Liberty Street Elementary School. I attended the Glasgow Junior High School, graduated from Glasgow High School in 1969. Went away to Harvard College and graduated in 73. Took a year off and worked under my father and joined the National Guard that year, and then entered the University of Louisville Law School in 1974, graduated in 77, came back here in 1977 to work with Mr. Richard Garnett, and I've been here ever since. The most important stop on the way was to meet and marry my wife, Ann, in 1975, and Ann and I are proud to be the parents of Campbell, who's age 19 at the University of Kentucky, and Alex, who's age 13 at the Glasgow Middle School. And that's about as complete a biography as I guess I've ever presented, Mr. Barrickman.
Thank you. Carla?
Well, I was born and raised in Cave City. My parents are Carl and Iola Whitaker, and they still live there. Graduated from Caverna High School, and then went to UK, graduated there with my bachelor's degree in 73. Went on to the UK Law School, graduated from there in 1976. And after I got out of law school, I spent a year clerking for Judge Charles Reynolds in the Kentucky Court of Appeals. It was in Bowling Green. And then came to Glasgow and practiced law for about 8 years. And then I moved to Cave City and opened my solo practice there and practiced there for about 15 years. The past 3 years, before accepting the appointment back in January, I served the Barren and Metcalfe Circuit Courts as Domestic Relations Commissioner. And essentially we tried the divorce and custody cases for the circuit. And then in January of this year, I was appointed to fill the vacancy in the new Division 2 for the district court.
Mitchell, where are you practicing now, and what has been generally your type of practice?
I'm very proud to say that the last 10 years I've been Walter Wynn Davis's partner. I had a solo practice from 1979 when Mr. Garnett passed away until 1990. And I've enjoyed very much being with Walter Wynn for a decade now. We do primarily plaintiff's personal injury work, real estate work. Walter does a great deal of commercial work in the bankruptcy practice on the creditor side primarily, and we both do decedents' estates and so on. We do very little domestic work. I've done a little bit, but very little. And because I served as Judge Ropp's trial commissioner in what's now Division 1 of the district court from 1994 to 1999, I was precluded from practicing any criminal law that would be in that court. Of course, most of the criminal practice in this district would arise in the district court and percolate up eventually to the circuit court. So my criminal practice, such as it was all prior to 1994. We do, as I say, primarily plaintiff's personal injury and real estate work, and have enjoyed that practice very, very much with Walter Wynn.
Carla, what has been the essential nature of your practice before you became Domestic Relations Commissioner?
Okay, well, primarily when I was in Glasgow we did some insurance defense and practiced in your firm, and did some banking law practice, domestic relations, and then when I moved out on my own and had my solo practice, primarily bankruptcy, real estate transactions, probates and wills, domestic relations, and just a general civil practice for the most part.
Mitchell told about his children. How many children do you have? Where are they?
I've got 3 children, and I've got Ben. He's a second-year student at the University of Kentucky College of Law. And there's Matey. She's at Western Kentucky's Technical College right now. And then there's Laura. We sent her off back in August to UK.
So you're about to be able to say you think you own a part of the UK.
I've got a stake in it, yes, sir.
What are the duties of the district judge, Mitchell?
The judge presides over the district court and has authority or power or jurisdiction, if you want to use that legal term, over criminal cases involving misdemeanors and traffic offenses. On the civil side, it presides over civil claims less than $4,000, small claims up to $1,500, with which everyone is familiar, I think. Then it also handles the juvenile cases and the probate cases. Now, there are thrown into there some miscellaneous matters as well, such as forcible detainer, involuntary commitments, disability hearings, and so forth. But primarily, the bulk of the docket would be in those areas I mentioned first.
Do you agree, Carla? Or have you got any additions?
I think you pretty well summed it up. Well, we also the district court also handles paternity cases, child support, which is a significant part of my docket.
And what about abuse cases on an emergency basis?
Okay, on you speaking of juveniles?
Well, anybody.
Well, yes, domestic violence cases come before the district court, and also any dependency, neglect, and abuse cases in the juvenile side of it.
That's been a recent addition to the jurisdiction, I think, has it not, Mitchell?
Yes, sir. As a matter of fact, when I was trial commissioner under Judge Rock from 1994 to 1999, a great deal of the work that I had to do with was the issuance of emergency protective orders. And as you suggested with the abuse element, that is the area where that appears. Since the early 80s, I believe, the legislature has addressed the problem of domestic violence by creating this opportunity to streamline the means, hopefully, for relief when there is domestic violence. And it begins with the issuance of what's called an emergency protective order. And that is the only involvement that I've had when I was trial commissioner. As Judge Allen said, the domestic violence orders can be issued only by the judge of the court following a hearing. But this indicates part of the development of the jurisdiction or the power of the district court since its inception in 1978, because as societal changes have taken place, so also have the judiciary has been made to sort of respond to those needs. And lamentably, domestic violence is a serious problem in our area, and the courts do its best to try to respond to that need.
Carla, you want to expand a little on your duties as the Domestic Relations Commissioner?
Well, it's a difficult, but I think very important job. As Domestic Relations Commissioner, essentially how that works, it's an appointment by the circuit court, and the commissioner actually tries cases of divorce, matters of child custody and child support, and then makes recommendations to the circuit court. And the circuit court can either adopt those recommendations in the form of a judgment, or upon a hearing of any party that requests it, they can review those decisions. It was a very busy docket. Domestic relations comprises a significant portion of the circuit court docket. Plus, it's also, in my opinion, a very important part of what the circuit court does, because it affects so many families and so many children. It's difficult because sometimes there are no clear answers, sometimes no right answers at all, and it takes a lot of soul searching, a lot of intent listening. It's an important job. It's in ways I enjoyed contributing to that, but it's difficult. And my hat's off to Temple Dickinson who does it now.
It does involve custody of children sometimes in divorce actions?
Yes, sir. Yes, sir, it does.
I'll ask you a personal question. Maybe you won't want to answer it, but it's been my observation that when a lot of couples get a divorce, they're more interested in fighting each other than they are protecting the child. or children? You
People
may
going-
not want to comment on that, but
Well, I think what happens, people going through a divorce are going through a terribly difficult time in their lives. Their emotions are all, well, they're very emotional. And sometimes they're very hurt by the circumstances that led up to the divorce action. And I think in that context, sometimes the children get, well, they forget the feelings of their children. I don't think they mean to, but I think it does happen. It happens quite often.
Mitchell, why do you want to be district judge?
I'd like to be district judge because I want to do something, Mr. Barrickman. I have spent the better part of the last 10 months in Metcalfe and Barren counties trying to explain to people that I want to do the best I can to continue to earn the public's respect for our district court. I think we have had a distinguished district court, as I said, since its inception in 1978, and I want to make equal justice under law a reality for our people. That is the challenge to which I have committed myself, and that is what I want to do if I'm elected judge of the court.
Carla, why do you want to be continue as district judge?
Well, I think I do have something to contribute to the bench in terms of experience in listening to people. And district court's a little different from any other court because most of the people that appear there are not represented by counsel. You have to listen very hard because sometimes when they're trying to tell you their story, they're not really adept at trying to, at saying what they really mean. You've got to listen very hard. You've got to know the right questions to ask. The 3 years as domestic relations commissioner, I think, has helped me develop the skills to do that. And district court is common sense. It's a very common sense type of court, and I think I can contribute a lot there.
Tell me a little bit more about what all you did as trial commissioner, Mitchell.
Most important things that I did as trial commissioner was to set bonds whenever people were arrested, and then to appear in Judge Ropp's absence occasionally at times of arraignments. I'll talk about that just a minute further, but I want to also add that one of the powers of the trial commissioner is to be able to probate wills and appoint fiduciaries. So I had quite a bit of opportunity to do that, which is a very administrative, fairly routine matter, but it is a very important matter and part of the administration of justice. Probably the function that I performed that involved the most interaction with other people was, as I've said, the setting of bonds and also the conducting arraignments in Judge Ropp's absence. The question about setting a bond is not as routine as it may sound, because the purpose, of course, is to guarantee that the person who is accused, who has been arrested, appear at the later judicial proceedings. It was always my idea that I wanted to make sure that the public safety was balanced into that calculation, and also that the role of the arresting officer was balanced into that calculation, so that there be as I say, a balance between the constitutional rights of the accused and also the necessity to maintain some order and some peace in the community. At times of arraignment, which I enjoyed very much conducting in Judge Ropp's absence, I too had the opportunity to interact with persons who would come before the bench who had been accused of crimes, and to try my best to interact with them in a courteous yet efficient manner. And I'm very proud of the years that I had in that particular capacity. In fact, it greatly whetted my appetite, as it were, to be elected the judge of the court.
What about juvenile cases? Did you have any experience in them?
There was very little authority or power that the trial commissioner has in the juvenile matters, except in emergency situations. If there was an emergency detention required, the trial commissioner had authority to act there. But it was very rare that I had to perform in that particular role. The job of the trial commissioner, I might add, is defined somewhat by statute, but primarily by Supreme Court rule, and that specifies what powers the trial commissioner has. And they are, I think, primarily an aid to the district judge, so that when his or her docket is not so much the docket is full, but his or her schedule is full, so that he or she is not available to attend, there is someone there that can see that the needs of the public continue to be met in their absence.
And I take it you had both Barren and Metcalfe County?
No, sir. I only had Barren County. Barry Gilley is the trial commissioner in Metcalfe County.
If you are elected, do you have any person in mind? I withdraw the question. You won't have trial commissioners this time because you got 2 judges. I wasn't thinking there.
I think you're right. As a matter of fact, I resigned as trial commissioner in January of 2000.
As soon as the other district court was created and became effective.
That's right.
What has been your experience with handling juvenile matters, Carla?
Well, since the appointment in January, of course, what Judge Romp and I decided to do in terms of dividing the caseload, for the most part, it's just divided right down the middle, but there are certain areas that we decided to divide in kind, and one of them is the juvenile area. I have the dependency, neglect, and abuse cases, and he has what's called the status offenses and the public offenses. In the
what kind of offenses?
Status offenses.
Okay.
For example, runaway teenagers and that type of thing. And in that course since January, we've handled quite a few dependence, neglect, and abuse cases through that side of juvenile court. One of the things that has very much interested me, which had not been used a great deal in juvenile court, was addressing truancy problems. As you may know, in Warren County they have truancy court, which has been functioning for about 2 years now. The purpose of that is to go into the local schools and address truancy problems in an elementary age, so that hopefully it doesn't become a habit and become a problem when the children reach high school. We have started kind of a pilot program that we're meeting at South Green Elementary, one school on each of the 4 systems in the 2 counties, Heisville, Caverna, and North Metcalfe. What we've done is to encourage some of the parents of kids who have had problems in attendance to come in at 7 o'clock in the morning. We meet with them and we start talking about what problems they're having of getting the kids to school. Family resources comes in and they lend any kind of assistance that might be necessary to try to work out the problems, and anything else might come up. Plus, we also encourage the parents to make sure that their kids are in all available programs that the school might have. For example, tutoring. Okay, if a child is getting behind in a certain course, we try to get them involved in a tutoring program that's going to help them. I would like very much for that to be expanded to more schools, and it's possible that funding may be found for a coordinator like they have in Warren County, so that they can handle more elementary schools in the program. So far, the results seem promising in terms of attendance of these children that were having problems. They're doing much better. So that's one thing that I've been working with a lot since we started. We started that back in August of this year before school started. So essentially, that's my view, or that's been my work in the juvenile side of district court.
Well, has you said it's worked well as far as the program, since the program has been instituted, but what has been the response? By that I mean numbers of people with children that having problems coming, or is it a small group?
We've had a fairly good response from most of the schools, and what we did was send out a letter to the parents of the children who had had significant attendance problems, and I haven't added, or figured percentages, but I'd say that 8 out of 10 have responded. Now, in some situations, we have let excuse those parents from attending the programs because the kids have just done wonderfully. Or it may have been a specific medical problem, for example, or something that that had caused attendance problems the year before, and that's been resolved, or whatever the problem was has been resolved. But overall, we've had a pretty good response from the parents.
Do the schools suggest students that need to be in the program?
Right.
So that's the beginning.
Right. They identify students that have had significant attendance problems, and then we invite those parents to get involved in this program to, see what the problem is and try to address the problems.
Insofar as appearances and holding court in Metcalfe County, how do you and Judge Ropp divide that insofar as days are concerned?
Judge Ropp goes on Wednesdays, and I go on Fridays.
Mitchell, do you think you are better qualified for the position than Carla?
I don't believe that qualification is a question in this race, Mr. Barrickman. I think that qualification and experience are Siamese twins. I think they're very closely related. 2 or 3 reasons I feel that. Number one, the Constitution says that no person shall serve as district judge until he or she has been admitted to practice for 2 years or more. Both Judge Allen and I have practiced considerably longer than 2 years. So I think in regard to qualifications, our qualifications are awash in that area. With regard to the matter of experience, I would like to say that I think that the position that the judge has right now came about as part of the process of filling that position, which began with appointment and will culminate with the first opportunity for the people to have an election on November the 7th. So I think that presents basically a wash as well. I very much enjoyed my time as trial commissioner, and even though I have not been very active in district court since January of this year, I feel like that I probably would bring to the job, if I'm elected, about as much experience in district court as Judge Allen had when she was appointed to the bench back in January. I think the qualification matter is a wash, and I certainly will not do anything or say anything to assail Judge Allen's qualifications for the job. I think we're pretty much neck and neck in that regard.
Carla, do you think you're better qualified for the position than Mitchell? I'll ask you the same question.
I do, for this reason, and it comes from having done the job as domestic relations commissioner. Deciding a case is something that takes some adjustment. It takes some real adjustment. When you take somebody's life in your hand, and the decision is up to you, it's an awesome responsibility. And having done that for 3 years has made me better suited, I think, to sit down and try to determine the facts of the case and apply those facts and apply the law in a humane manner. The decisions aren't always easy, and they're not always black and white. And that takes a good deal of experience and knowing, being able to sit back and look at a situation, come up with a judgment that's both fair and in accordance with the law.
Mitchell, as trial commissioner, you had considerable experience as far as probate practice was concerned, handling the probate practice. Just explain to the audience what you mean by and what the term means, probate practice.
Probate is the process of administration of what we call a decedent's estate. Decedent is the legal name for someone who has died. The only involvement that the trial commissioner could have in probate was simply to appoint fiduciaries and admit a will to probate. In other words, whenever John Doe passed away, then the person who in his will he had named as his executor would normally retain an attorney and would come to see, in my case, the trial commissioner, and offer the will, and there would be, unless it were what we call a self-proved will, which is a form that the statute has authorized, there would be a witness to prove that this was the person's last will. then an order would be signed by the trial commissioner stating for the record that the will had been admitted to probate and that the person named in the will had been appointed as the executrix. Normally, a will waives a surety on the fiduciary bond, so there was no problem in trying to examine about the adequacy of the surety because there would be no surety. Now, that was the extent of the involvement of the trial commissioner in probate practice. The judge of the court, of course, has considerable more supervisory authority because he or she must, at the very end of the probate process, at the very end of the administration process, review a final settlement that the fiduciary, the one set in the state, would submit showing the assets received and the disbursements made, and to show that all claims have been paid and all other obligations satisfied. The trial commissioner has nothing to do with that. That is strictly a judge function. But my involvement was on the initials end in terms of admitting the will to probate and appointing the fiduciary. It is a function which is sad because there has been a death of a loved one, but it's also a function which is very satisfying in the sense because I think that at least I made an effort always to try to show some compassion and concern for the family at that very unpleasant moment, unhappy moment, and I hope that it showed a proper function or a proper response of government to the people's situation.
Now, you've talked principally about wills and probate of wills. What if there was no will?
If there was no will, the trial commissioner also had the authority to appoint what's called an administrator, which is the fiduciary, the one responsible for winding up the estate, if there is no will. And occasionally I would be called upon to do that, but very rarely. Normally the probate experience that I had was where there was a will and for the appointment of an executor.
And I believe that the law requires if you appoint an administrator that there has to be a bond.
That is correct, because in that situation there's no will to say no surety required on the bond, and normally the amount of the bond is set at the value of the personal estate. The law treats real estate and personal property differently, and this is something a lot of people have difficulty understanding. It took me 3 years of law school to figure it out, at least the probate course anyway. But the ownership of land where there is no will passes immediately to the heirs at law. If there is a will, it passes immediately to what we call the devotee under the will. Only if the will allows the executor power of sale does the executor become involved in dealing with real estate. Personal property is a different matter. The whole purpose of administration of the decedent's estate is to enable what we call a personal representative, a fiduciary, an administrator or executor, to take charge of that person's personal property, to collect all the assets, pay all the claims, and pay other obligations, and at the end distribute the assets or the residue of the assets to the heirs at law as their interests appear. So normally the bond would be set at the value of all the personal property, and the only purpose of that bond, which of course has to have the fiduciary as a principal and then someone else as a surety, is to guarantee that if the principal, for whatever reason, defaulted, ran away, stole from the estate, that there would be a means for the property to be restored and administration proceed in an orderly fashion. I'm happy to say that I have never seen a fiduciary misuse or abuse his or her power. And so for that reason, these bonds are somewhat quaint, but once in a while, not in my experience, but once in a while, there will be a need for that bond to be put into play. But I'm happy to say that was never a problem.
Define surety. You use surety.
The surety is one who guarantees the performance of duties made by a principal if the principal fails to perform those duties. I would normally tell the principal or the surety to make sure that the principal didn't run off with the money to Hawaii or something before they got finished settling the estate, otherwise the surety would be responsible. But the surety is just someone who is the backup person to make certain that the value of the estate is there for administration and distribution if the principal fails to perform the duties.
Now, Mitchell mentioned fiduciary and the duties as such. Are there any other fiduciary responsibilities, so to speak, in the district court, Carla?
Well, yes, we have the fiduciary responsibilities for guardians and conservators of people who are disabled and of minors. If a minor comes into some money or needs to transact some business, then a guardian needs to be appointed, and that person is also a fiduciary responsible to the minor. Also in situations where a person becomes physically or mentally disabled from taking care of their business, at that point the court appoints a fiduciary called either conservator or guardian, depending on the needs of that individual. That person is also fiduciary responsible to the estate of the disabled person. So those are two areas, yes, that we also have fiduciary responsibilities and fiduciary, I guess you would call it the oversight of the fiduciary's duties. In other words, all fiduciaries must make an accounting to a court of all the money that's taken in and all the money that's expended on behalf of the individual or the minor.
How often is that required, Mitchell?
Biannually, every 2 years. My recollection is that the settlement, the periodical settlement, is probably made after the first year and then biannually thereafter, if I'm not mistaken. And it is an excellent legal requirement because it makes sure that the assets, as we say, are not dissipated, that they're not frittered away. You're aware, I'm sure, Mr. Barrickman, of some very tragic cases in the Commonwealth where fiduciaries have abused their roles as guardians, particularly for minors. And here, assets that were supposed to be available for a minor were no longer available. So the legislature responded with that, with tightening up, I think, some of the reporting requirements. And I'm not sure if that made more frequent the filing or not, but nevertheless, the legislature did take steps to try to prevent the recurrence of that. And one of the means is through periodical settlements, settlements that are filed, as I say, either, I think, annually the first time and then every 2 years thereafter, so that the court has an opportunity to see exactly what the fiduciary is doing with the funds in his or her control. Certainly in that situation, the surety on the bond is terribly important because if there were a default, then the surety would be there to come into play. In those cases, normally you have what's called a corporate surety, an insurance company or other corporation whose solvency is without any doubt. But I must say I can't recall exactly when the legislature made those improvements. Seems to me like there was probably one period of time in which the district judge was personally liable on those bonds, but my recollection is that that was changed by law. But the point is, regardless of the chronology there, the point is that there is a means under the law which the district judge has to oversee to make certain that the assets of a ward, of a person who has a guardian, are properly managed, and that is done through reporting.
Once a report is filed by a fiduciary, regardless of whether it's an estate or some other fiduciary duty, what's the duty of the court? What's the court supposed to do?
First thing the court does is the court sends out a notice that a settlement has been filed to the heirs or the family or interested parties with regard to that matter. And then the court examines the accounting to see if it balances, see if there are any suspicious looking expenditures or anything else out of the ordinary. And if it finds that there's something out of line, then they require the fiduciary to come and explain what they've done or make any necessary corrections to the accounting so that every penny is accounted for.
Now, both of you have mentioned the matter of bonds being required in one aspect or another, and Mitchell in the beginning gave some indication of what should be considered in fixing a bond in a criminal case in particular. Let's expand on this bond situation a little bit more. What factors do you consider, Carla, in fixing a bond in a criminal case?
Okay, well, the whole point of allowing people to post bond to get out of jail before their trial is the fact that, you know, we do presume a person to be innocent until they're proven guilty in a trial. On the other hand, you balance off the, I think as Mitchell pointed out earlier, the safety of the public with regard to that person being released. One of the things that you do look at is their stability in the community. How long have they been here? Do they have a job? Do they have family? Do they have factors that will keep that person in the area? Because that's a key to it. What you're looking really in setting the bond at the likelihood that they will appear and be held over for trial. On the other hand, if you've got somebody who is not a resident of the state, who has not had a history of within the community, then you're more likely to set a higher bond to guarantee his appearance for trial. And we have other ways of, we have surety bonds with that too. Sometimes there are property bonds whereby a person comes in and pledges their property to guarantee that person appears for trial. Sometimes somebody will sign a surety, as Mitchell pointed out. They'll guarantee, X number of dollars. And if that person doesn't appear, if they disappear and don't respond to the charges, then that bond can be forfeited. And in some certain circumstances where you have a cash bond, that just is straight out forfeited. The other one is if you've got a surety, you bring that person into court to hold them responsible for the amount they guarantee the bond. So those are two ways of kind of guaranteeing that your defendant's going to respond to the charges in court.
You want to add anything, Mitchell?
I'd like just to add that it became my practice as I became more familiar and at ease with performing the role as trial commissioner, to be very certain as well that if there were a person, as Judge Allen said, whose connections with the community were not well established, to give the police agency an opportunity to investigate this individual a little bit further to see if he or she might be a fugitive from another state. And I took that position, again, because recognizing the responsibility that a judicial officer, even a little trial commissioner, has in terms of trying to maintain public safety. I cannot recall an event in which we were able to find that an accused person was a fugitive from another state, but it always gave me peace of mind to know that the investigation had been made, and I feel like that the law enforcement agencies with whom I had the great pleasure to work appreciated that attitude by me, and that would certainly be an attitude that I would want to carry over should I be elected as judge.
And I might add too, one of the other factors I think that you look at it, if it's a violent situation, sometimes you'll set the bond a little higher just to let there be a cooling off period, and so that figures into it too.
Now that raises another thing I've wondered about. That's where you, in an emergency, the district court can issue, in abuse cases, an order that they remain away from the spouse and so forth. How effective is that?
Effective in terms of persons obeying that order?
And how effective is it that the order is obeyed, or whether they have to come back to court for failure to obey it?
We have, I'd say we see several cases. Now, once an EPO or a DVO is issued, in addition to...
Well, now explain your terminology.
Okay, I'm sorry. The emergency protective order is an ex parte or a one-sided order. It is issued upon a person coming in and making allegations under oath that there has been violence or some other dangerous situation occurring in a domestic situation. You don't get two sides of the story. You just get the one side when that emergency order comes in. One of the things that has to be alleged that there is a serious emergency situation that cannot wait until a hearing. And if the court's...
Now, who makes that?
That decision is made by the district judge.
No, but who presents the evidence, if any, that it is an emergency situation and that an order needs to be entered to possibly prevent violence? How do you get the information to issue the order?
Well, in Barren County, we have a victim's advocate that works out of the county attorney's office that takes that person in and tries to discern what the facts are. A lot of times they're emotionally overwrought. They help them try to figure out what the situation is and get it down on paper. In Metcalfe County, that's usually handled in the clerk's office. Or during the daytime, the judge's secretaries, both of them will help these people fill out the petition for an emergency protective order. Then if that order's issued, it is set for a hearing that has to be within 2 weeks. The emergency protective order is only good for 14 days. So we try always to set the hearing on that within that 14-day period. If for some reason the respondent has not been served, the court has the authority to extend that emergency protective order for another 14 days in order to allow the respondent to be served and be present for the hearing.
Mitchell, are the police officers or the law enforcement officers allowed to make the complaint?
In my experience, they did not. The complaint was made, as Judge Allen explained, by the victim in exactly the procedure that she described. When I was trial commissioner, it primarily came to me from Judge Ropp's secretary, as Judge Allen explained. I could remember on, I think, probably the first Easter Sunday I was trial commissioner, I found myself at the police station filling out one myself for a victim, to try to aid a victim, because no other officer could be found to do that. So I did the intake, interviewed the victim, and issue the order. And of course that was done at the police station, so there was some police involvement there. But my experience as trial commissioner was that the law enforcement agencies were not involved at the initial stage of the EPOs. Of course, it would be the emergency protective orders. It would be the responsibility of a law enforcement officer to serve that order on the defendant in that situation. And let me add, if I may, that as I said a few minutes ago, that the emergency protective order and domestic violence order plan that is in our statute is a response by the legislature, the lawmaking branch of government, to some serious societal problems that we've come to experience. Probably the best function that these emergency protective orders plays is to provide some immediate separation of the parties involved, because there is no bond, by the way, in an emergency protective order because of the emergency character of it. And normally the purpose is to separate these parties apart and hopefully let a status quo return until the hearing can be had, and then the court, the judge, make a decision whether or not the situation is serious enough to require the entry of a domestic violence order to continue these separation terms and so on. I can tell you that I declined to sign an emergency protective order on only about 2 occasions. There was one occasion I remember in which the legal requirements had not been met, in that the relationships, as I recall, that the law requires did not exist. The family connections did not exist. And in the other case, the alleged act had taken place too remote in time to be under the purview of the statute. The point is, in most cases, I, as the trial commissioner, absolutely would take very seriously these allegations, because I felt that, as Judge Allen said, on the ex parte, on the one-sided end, it was my obligation to be very concerned, excessively concerned perhaps, to the situation of the alleged victim. That's the reason, though, we have the hearing, or the judge has the hearing on to determine whether or not to issue a domestic violence order. It is that stage where everybody is entitled to a hearing. And I would not want anybody, the public, to think that the courts are making decisions about everybody having a right to be heard. The opportunity to be heard is at the hearing, after which, in some cases, the judge issues the domestic violence order. It is a legal response to a severe societal problem that unfortunately does mean that for a period of time, 2 weeks, as Judge Allen explained, there's only one side that has been heard. But that's why the hearing at the domestic violence order stage is so important. And I say again, as trial commissioner, my only involvement was at the issuance of the emergency protective orders. I had no authority past that point.
Suppose the need arises at 2 o'clock in the morning. Then what happens?
What happened in my instance was that of course, obviously they're not going to see the judge's secretary at that point. They would go to the Glasgow Police Department is the most available police agency. It's open 24 hours a day, and would go in there, and probably the county attorney or assistant county attorney on duty that night would normally do what I said I did on my first Easter Sunday as trial commissioner, that is take in the information. Then customarily the dispatcher would call my home and say that if they couldn't find Judge Robb. Now at 2 o'clock everybody knew where Judge Robb was, so I didn't have any problems at 2 o'clock in the morning. But occasionally if he were out of town, perhaps after midnight, that they weren't able to find him, then they would call me, and I tried my best to be available, and which would certainly be my practice if I'm elected judge, and would ask the dispatcher to send a police officer in a cruiser to my home. And usually in the foyer of my home there would be signed the emergency protective order or whatever other process was necessary. If it was an arrest warrant in those cases or whatnot, that's the way it was done. And I feel like the law enforcement officers would agree that they found me to be very cheerful and cooperative in all those situations, because I think that is the responsibility of the judicial officer to assist or facilitate in the administration of justice under any circumstance, regardless of the time of day.
Under those circumstances, that is 2 o'clock in the morning, how do you handle it?
You just do it. What I have done, I've installed a fax machine at my house. And I find that to work quite well for a lot of orders. There are some things that doesn't work for, but if it's something in a nature of a DVO or that, I find that to be a lot quicker than having to send an officer out to the house. And then I take the original signature on the documents and file it in court the next day. You just do what you have to do. 2 o'clock, 4 o'clock, whatever.
Now, either one of you may answer this, and then we'll get into something else. What's the salary? What's the salary per year for the district judge?
90-some, and I can't tell you exactly.
90-some thousand.
Mm-hmm.
You agree, Mitchell?
Yes, sir. That's my understanding. I was very happy that the newspaper published that after the filing deadline back in January.
Since the public has heard that we were going to have this meeting tonight and so forth on Glasgow Wants to Know, I have been asked, and of course I can't answer it, but I've been asked why in the world somebody would spend more money trying to get the office than it pays the first year you're there. Of course, that is an indication that your campaign is costing more than the first year's salary. Do either one of you want to comment about that?
I'll be glad to comment about that. I can't threaten my children anymore with disinheriting them because they know there's no more inheritance left. But the reason for that is if you look to see where the money is spent, it is spent primarily, and I think Judge Allen would agree, on advertising. And I want to get on a soapbox on this, Mr. Barrickman, because I feel very, very passionate about this. We had a primary back in May in which fewer than 1 out of 5 registered voters went to the polls and voted. That is after Mrs. Howard, Judge Allen, and I did the very best any of us could to try to get the attention of the voters, to try to let them know about the race, and to try to justify our candidacies. As a matter of fact, I spent out of my campaign almost $1,000 back in the late winter, January, February, just to get on the air commercials so that people would realize I was not running against Judge Robb, because the public didn't understand what Division 2 of the District Court was about. The idea is that in a political campaign, whether it's ours or any others, the candidates have to communicate with the voters to try to get their attention and hopefully to persuade them to give their loyalty to that particular candidate. I regret very much that only 1 in 5 voted in the primary. I'm confident that a substantially higher proportion will vote in the general election, because the presidential race the city councils in certain races or in certain cities, and then some other issues that are on the ballot. But communication is one of the most important problems with which a candidate has to deal. And we have done that, both Judge Allen and I, and in the primary, Mrs. Howard, have done that through all possible available means, through enormous amount of door-to-door campaigning, person-to-person, through an enormous amount of public event visitation, whether it be fish fries or pancake fries or whatever, and through radio, television, by the grace of the Electric Plant Board here, and newspaper. If anybody ever tells you about freedom of the press, don't believe them. It ain't free. It's very, very high. But those are the media that we are compelled to use in order to get the attention of the public. If we lived in a utopian society when every voter was fully responsible for his or her duties, we as candidates would not have to spend near the amount we have to get their attention, communicate their message. But believe me, I think Judge Allen would agree, we share the revulsion for the expense, because it is we primarily who have to bear it, along with those generous people who have helped us with their contributions.
You still haven't answered the question, Mitchell.
I think I did. I tried to.
The question was, by the public, is why in the world would anybody spend as much money as they do for campaigning, and it would amount to as much as the first year's salary?
Well, with that regard, I would say that in this case you have two highly motivated people, two people who are, I believe, capable and competent, two people who want to continue in the careers that we've spent a lot of time and money preparing ourselves for, both in education and in practice. And we would like to further that in some way that is both personally satisfying and remunerative. And I make no apology for wanting to have a job that pays well. If I'm elected to this job, I'll make more money than I've ever made in my life, with the exception of one or two very, very unusual years. And I make no apology for that, because the responsibilities of the office are proportionate to the compensation. But the motivations that people have to do things, I think, are fairly subjective. In our cases, I believe that we are both, as I've said, highly motivated people. One of my friends, who's now deceased, who was a very successful public official in this county for a number of years, is reported to say that it was normally worth it to expend on a campaign the first year's salary. I hope mine doesn't quite get that far along, but the campaign's not over yet, and it might. But I think that you have to look at what motivates the individuals, and Judge Allen and I think, share a professional zeal that we would like to continue to do the best we can in our profession, and this opportunity was obviously, designed for exactly that purpose.
What's your response, Carla, to the question? That, as I say, it wasn't my question. I've been asked the question by the public.
Well, it's gotten, of course, this race is particularly expensive because because we had the primary race, which was essentially a race in itself, and then the fall race. So I think Mitch will probably agree, we've probably done twice what we would ordinarily have allotted to doing this type of thing. And advertising is very expensive, and I think that's where most of the money has been spent. You do what you have to do and spend what you have to spend to feel competitive in a race. I think it is a shame that running for office has become so expensive, but that's part of it.
Or do you have to file any reports about your?
Lots of reports.
What reports do you have to file, Mitchell, and what do they tell?
When a candidate files for election to public office, one of the agencies with which he or she must file is the Kentucky Registry of Election Finance. I suppose the acronym is CREF, I don't know, but anyway, it's CAREF. And we are required before the primary to, and by the way, we were required to file papers showing who our campaign manager is and who our campaign treasurer is, who is the officer responsible for receiving and processing the financing. And I believe it's about 32 days prior to the primary election, and then maybe another 10 or 15 days before the primary election, and then about 30 days after the primary, a report is filed, and essentially the same plan is in place for the general election. So there are certainly reports that are required to be made to show, and this is very similar, I think, to a settlement in the decedent's estate, the receipts that have come in and the disbursements that have been made. And all of this is part of the effort to make sure that campaigns are accountable and that the public is enabled to know the sources of financing. This is sort of a post-Watergate reform, I suppose, that trickled into the state government after it was handled at the federal level. And as you know, it remains a burning issue at the federal level. And I think for many years to come, we're going to see campaign finance issues surface anytime there's a political race.
The reports are also supposed to be filed, are they not, in the county clerk's office?
I believe that is, I'm sorry.
In the county of the candidate's residence.
Well,
so in other words,
in the clerk's office of the...
we file here in Barren County.
But you don't have to file in Metcalfe County?
No, just as I read it, just the county of the candidate's residence.
Those records are public records. They're available for anybody that wants to peruse them.
Now, what all do they, I'm sure they're supposed to contain contributions. How about money that you all put up, each one of you puts up of your own?
Yes, we're contributors, sure.
Those are reflected either as an outright contribution or sometimes carried as a loan to the campaign, which of course has to be assumed by the candidate afterwards. It also shows anybody making a donation of $100, or excuse me, over $100 has to be itemized. Cash contributions have to be shown. There are limitations on the number of cash contributions, limitations on the number of anonymous contributions you could have, and then you have to show the individual contribution limitations. Since there's $1,000 per individual limitation per campaign, you have to keep a running total for each contributor to make sure you don't exceed that individual limitation. So there are several things that have to be shown on this report that goes in. And I think you have one that's 30 days before the election, 15 days before the election, and then one that's post-election that has to go in.
So, as you all file your reports, both before and after, they are accessible to the public, and anybody wants to see what each one of you are spending and where you're getting it, they can go to the county clerk's office and here in Barren County, and of course a resident of Metcalfe County could come over here if they wanted to see it, and it is a public record for anybody to inspect.
Yes, sir.
I personally want to emphasize something that Mitchell commented on, and that is the need for everybody to get out and vote. We hear an awful lot of complaints about what the government does and what the government doesn't do, and how they're wrong here and how they're wrong there. And yet, basically, insofar as our system is concerned, it is known as a representative type of government. And you don't get your say unless you vote and elect your representatives. And you really have no right to complain about your representative, whether it be locally or nationally, unless you help choose them and get out and vote. The office to which these two candidates are seeking is a very important office in this county and in Metcalfe County. As you have heard here tonight, there are many responsibilities and many duties involved in the office. So I urge you to go vote yourself. I urge you to talk to your friends and members of your family. I observe quite often that you'll have maybe the wife will vote or the husband will vote and the rest of the people in the family will not vote. So I urge you to get your family out to vote, your friends out to vote, because it is only that way that you actually contribute to the type of government that you have and in doing that you will fulfill your duties as a citizen. I appreciate both of you being here tonight. I think you've enlightened the public, and I thank you very much for coming, and we're out of town.
Thank you for asking us.
Thank you, Mr. Barrickman.